Hello friends, today we are going to discuss about child in conflict with law under Juvenile Justice Act of 2015, amended in 2021. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. For legal opinion, please do contact an advocate. For clinical opinion, please do contact a psychiatrist. This presentation is not an alternate for professional opinion. Conflict of interest? None. In this video, I'm going to discuss about Juvenile Justice Act, that is 2015, amended in 2021, specifically discussing about the child in conflict with law, Juvenile Justice Board, and procedures regarding the child in conflict with law, how it is dealt in front of Juvenile Justice Board. This video is targeted to psychiatrists, registered medical practitioner, nurses, advocates, Juvenile Justice Board members, Child Welfare Committee, Special Juvenile Police Unit, Child Welfare Police, personnels working under the Ministry of Women and Child Development, personnels working in the child care institutions. For them, this video is very helpful. Let's discuss about children in conflict with law. If you look at the legal framework under which this comes is basically it stems from the Constitution of India, Article 15, 39, 45 and 47. I have discussed about these articles in my first video on Juvenile Justice Act, that is Introduction. Please watch that video. Along with this, India had ratified United Nations Convention on Rights of the Child in December 1992. That means we need to align our local laws to protect our children. Hence, we came up with different legislation. The first one was Juvenile Justice Act of 2000. But however, there were a lot of shortcomings. Hence, it was repealed and Juvenile Justice Act of 2015 came and minor modification with amendments in 2021. Along with this, you can also see Commission for Protection of Child Rights Act of 2005 came in. Further, Protection of Children from Sexual Offence Act of 2012 came. So with this legal framework, we required a robust law. Hence, Juvenile Justice Act of 2015 was brought in, along with that, with minor modification and amendments in 2021. Then what is the issue when a child is in conflict with law? That is the main objective of this video. That comes in the defense of infancy. That means the defense of infancy is a form of defense, that is an excuse so that the defendant falling with the definition of infant are excluded from the criminal liability. Imagine a child has committed a crime, or else usually we consider, especially after Juvenile Justice Act of 2015, amended in 2021, we don't consider a child as a criminal or an accused. We usually consider them as child in conflict with law. Here, the child does not have the mens rea to commit a crime. That means it does not have a malified intention. Because of various developmental issues in the brain, the child gets in conflict with law. Hence, the child does not have that malified intention to commit a crime. Hence, it will not be considered as a guilty equivalent to a manslaughter or to a murder. Here, it is in conflict with law. That means the child has not developed to that level to understand what is crime. That's where the defense of infancy stems out. This has been clearly coded in Indian Penal Code, Section 82. Here, if an act is done by a child under the 7 years of age and which is against the law, it will not be considered as an offence. Section 82 is clear. Nothing is an offence which is done by a child under 7 years of age. That is Defense of Infancy, Section 82. If you move further, that is Indian Penal Code, Section 83. Here, act of a child above 7 years but under 12 years and which has immature understanding. That means if a child is between 7 and 12 years and it has been in conflict with law and it is unable to understand, that means it has an immature mind, then the child will not be punishable. If you read that, it clearly says, nothing is an offence which is done by a child above 7 years of age and under 12 years who has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct on the occasion of commission of crime. That means the child will not be again held responsible under Section 83 of Indian Penal Code. But however, the issue remains again a big question. What will happen to the child between 12 years to 18 years? That means there are a huge number of children who fall into this category. Will they be punished or not? Because we have signed United Nations Child Rights Convention. We need to align our law. Hence, a huge task was taken to discuss about Juvenile Justice Act. And to summarize the defense of infancy, you can see the spectrum. 0 to 7 years, any conflict with law by a child completely absolved under Section 82. If it is between 7 to 12 years of child, it will be minimized, because here, if the child does not have the maturity or the intellectual development, in such a scenario, the child will not be punished or will not be considered as a criminal. But however, this was the older thinking. But however, now after JJ Act, between 16 to 18 years, we consider them, if they have committed a heinous crime, whether they had a physical capacity or mental capacity to commit a crime, a preliminary assessment will be done. And on that basis of the assessment, either it will be tried as a child or else as an adult. We will discuss, because that is the amendment which has occurred in JJ Act of 2015, and further it was amended. So let's discuss about that. That is Juvenile Justice Act of 2015, amended in 2021. This legislation was passed on 9th of August 2021. This is the amendment I am speaking. However, we need to discuss about this legislation in detail. Here, in this legislation, the preamble is very clear. It talks about two groups of children. That is, a children alleged and found to be in conflict with law, and also children who is in need of care and protection. So in this video, I'll be focusing more on conflict with law. That means the child who is alleged or found to be committed a crime. So that we will be discussing. If you look at this, the preamble is very specific. Children in conflict with law. It will discuss about how the child is apprehended. That means usually we call it as arrest, but we are not going to use this derogatory or stigmatizing words to the children. So it is apprehension, detention, prosecution, penalty, imprisonment, rehabilitation, and social reintegration. So those are discussed for a child who is in conflict with law. If you look at the child in need of care and protection, what is the procedure adopted? What is the decision taken by Child Welfare Committee? Orders relating to rehabilitation, adoption, reintegration, and restoration. So this is about the child care. A child who requires care and protection. That is, which is under the Child Welfare Committee. I'll be doing a separate video regarding child in need of care and protection. This video, as I mentioned, is only for child in conflict with law. If you look at this legislation, there are 10 chapters and 112 sections. So here, we will be discussing only on child in conflict with law. Who is a child under this legislation? A person who has not completed 18 years of age is considered as a child under this legislation. So, what does a child in conflict with law means? A child in conflict means it has two important criteria to be met. A child who is alleged to have or found to have committed an offence and who has not completed 18 years of age on the date of commission of the offence. That is very specific. That means the child who is alleged, basically accused, alleged or found to have committed an offence and the child has not completed 18 years of age. That means that is considered as child in conflict with law. So, as you know, the Juvenile Justice Acts deal with 8 important components. One is in conflict with law, child in need of care and protection, rehabilitation and reintegration of the child, adoption of the child, offences against the child, and miscellaneous. So here we are discussing about the child in conflict with law, which is basically Juvenile Justice Board, which have been clearly discussed under section 4 to 9, and the procedures how the JJ board has to work is discussed from section 10 to 26. if you look at this table, it clearly says under Chapter 3 is Juvenile Justice Board, discusses from Section 4 to 9, and Chapter 4 discusses about procedures in relation to children in conflict with law. That means how the JJ board will function. That is from Section 10 to 26. Let's discuss about the Chapter 3, that is Juvenile Justice Board, who is going to deal with child in conflict with law from Section 4 to Section 9. Let's discuss about Juvenile Justice Board, which has clearly one principal magistrate and two members. The principal magistrate either should be a metropolitan magistrate or judicial magistrate of first class with 3 years of experience is very essential. Further, it also says that they should have a special knowledge or training in child psychology and child welfare. Those are these magistrates who will be nominated for Juvenile Justice Board. Further, if you look at that, there are two members who are social workers. One of them must be a woman. And these members will be nominated by either they should have a degree in child psychology or psychiatry, sociology or law. Or else 7 years experience in health, education or welfare activities pertaining to children. So these are very essential components to be nominated to be a Juvenile Justice Board members. But however, there are clearly mentioned who cannot be nominated. For example, if either of them have done a human rights violation or a child rights violation or abused a child, or else they have been dismissed from the government services, they will not be elected or nominated for this post. Further, there are important things now we should understand. How a child will be dealt in Juvenile Justice Board. Section 5 and Section 6 clarifies this very clearly. If there is a child who has been alleged to have committed a crime before the age of 18, but however, the inquiry started after the age of 18, what shall we do? Imagine the child had committed a crime at the age of 17 years, but he was apprehended only at the age of 18. That means now he is arrested at the age of 18 and the time of arrest he is adult. Will he be considered as a child or adult? The legislation is very clear. Since the commission of crime was when he was a child, he will be dealt as a child. Further, in the Section 6, it also clarifies it is not the time of inquiry or the time of arrest. It is the age of the child when he has committed the crime. That is Section 5 and Section 6. So you have to understand, it is the date of commission of the offence. That is commission of the crime. So it is not the date of when the police came to know the child has committed the crime, or else the day of arrest or apprehension, or the date of inquiry has started, or else the proceeding of the date. That is not considered. It is the date of commission of the offence. What was the age of the child? That matters most in this Juvenile Justice Act. Let's understand clearly. Here is a child who is 18 years old and has committed a crime or offence at the age of 17. But he was missing. He was not to be traced at all. But the arrest occurred at the age of 19. That means apprehension has been done. Now, whether the child will be considered in the adult court or maybe in the child, he will be considered as a child because offence occurred at the age of 17. Further, even the proceeding occurs at the age of 21, still he will be dealt as a child because the commission of the crime, during that time his age was less than 18. Let's understand procedure in relation to the board, which is discussed in Section 7. The Section 7 clearly says that the Juvenile Justice Board should have child-friendly procedure. It will not have an adversarial procedure similar to the court, the way the people are brought into the court and the judge will be sitting on the higher pedestal, that is basically on the stage, and the witness has to sit down. So those kind of the uniform, the way the judge will be wearing and also the lawyer will be wearing, those kinds of adversarial procedure will not be allowed here. It will be child-friendly procedure. No intimidation is allowed here. It should be as normal as possible so that the child can interact and discuss with the JJ board members. Here, JJ board members will sit as and when required when the child is requiring support and help. And it should not be like a court, which I mentioned. And also, the child can be produced before any member. Either there are 3 members and these 3 members, in front of anyone, the child can be produced whenever it is in conflict with law, when the JJ board is not sitting. Once the JJ board sits, the decision has to be by majority. That means 3 people should be there. That is very essential. So at least one JJ board should be formed per district. But if there are many number of cases, the state government can form more than 1 or 2 or 3 JJ boards per district as much as it is required. Moving to section 8, that is power and functions and responsibility of the JJ board. Here, the JJ board can try for all children who are in conflict with law. The other courts which are given power is Children Court and High Court. Of course, the Supreme Court can try all these matters. Further, informed participation of the child and parents is essential whenever the child has committed a crime or an offense. Here, the child should be given information and the child should be participating in the trial. That is basically in the discussion. At the same time, child rights needs to be protected when JJ board is sitting. It cannot just waiver off the child rights. At the same time, legal aid should be given. And if the child is from a different district or a different state and speaks a different language, then the translator should be available so that the child understands what is happening there. JJ board further will order the probation officer to file the social investigation report. Based upon the social investigation report and other information, the JJ board will adjudicate the case and pass the degree. Further, when they are passing the degree, the rehabilitation component should be there so that the rehabilitation and restoration of the child back to the community should be very well marked in that judgment. Further, the JJ board also has been given responsibility to inspect those institutions where the child in conflict with law are kept. Coming to the section 9, procedure to be followed by a magistrate who is not empowered under this legislation. Imagine if a child in conflict with law is produced in front of a magistrate who is not a JJ board member and also does not qualify to be a principal magistrate as per the law, that is section 4 of the JJ Act. Such magistrate immediately, without making any delay, will forward or will send the child to the JJ board for further proceedings. That means he should not wait and he should not take the case into his hand. He should forward the child to the JJ board. Moving to the chapter 4, that is procedure in relation to child in conflict with law, that is section 10 to 26. Here, how a child in conflict with law is dealt by the JJ board will be discussed. That is, the procedure has been clearly been marked under the Act. First and the foremost, section 10, apprehension of a child alleged to be in conflict with law. That means a person who is going to apprehend the child should be a special juvenile police person of the unit or a child welfare police. And whoever is going to apprehend the child, within 24 hours, he should produce the child in front of the JJ board. The time for excluding the travel will be excluded. That means if a child is arrested from a village and he has to take the child to a district to produce in front of the JJ board, the time travel will be excluded. And then within 24 hours of excluding the time for travel, he should produce the child in front of the magistrate at the earliest date, that is in front of the JJ board. Moving to section 11, role of a person who is in charge of the child when the child has been apprehended. That means either the SJPU, that is Special Juvenile Police Unit, or a child welfare police. That person has to consider as his own child and maintain the child during the travel or during the production of the child in front of the JJ board. The law is very clear. Section 11 clearly says, as if the said person, that means who is in charge, was the person's child's parent and responsible for the child's maintenance till the child is placed back with the parents or the guardians till he is produced in front of the JJ board. That means he has to take care as if it is his own child. That is the way the spirit of the law has been clearly coded. Moving to section 12. Bail to a person who is apparently a child alleged to be in conflict with law. Here, whether if a child has committed a crime, it may be a petty crime or a serious crime or a heinous crime, whether the bail will be given or not. By the rule of thumb, the bail is usually given. It clearly says in the section 12, to be released on bail with or without surety, or placed under the supervision of the probation officer or under the care of any fit person. That means The rule of thumb is give bail to the child. The bail can be rejected only under three circumstances that has been clearly coded under Section 12. It clearly says bail will be rejected only if the child comes in association with the known criminal. If whoever is a criminal, and by chance imagine his uncle or a father is a known criminal, and if you give the bail, the child will go back with the parents and who is a criminal, and again child will be involved in criminal activity. In such a scenario, the bail will be rejected. Further, moral, physical or psychological danger to the child is there. If you send back the child by giving bail, and if this moral injury or physical injury or psychological injury is there, then bail will be rejected. Again, this is a word which is very broader in sense. That means JJ board has been given lenience to give or not to give bail based upon the interpretation of the situation of the child. Further, if the release of the child would defeat the ends of justice, that means you want to do justice to the child, also to the community. In such a scenario, if there is a defeat for the ends of justice, then also the bail will be rejected. And in such a scenario, whenever the JJ board rejects the bail, the child should be kept in the observation home. And these observation homes should be monitored and inspected by JJ board. Further, Section 13, information to parents or guardians or probation officer. Imagine a child has committed a crime or alleged to be has committed a crime. In such a scenario, Special Juvenile Police Unit or a child welfare police, once he apprehends the child, will inform the parents or the guardians that we have apprehended the child. Please be available in front of the JJ board. That is the duty of the probation officer to tell the parents. Further, the probation officer or the child welfare police officer need to prepare and submit social investigation report within 2 weeks after producing the child in front of the JJ board, because the JJ board will ask the probation officer to make this social investigation report. Further, coming to Section 14, inquiry by the board regarding the child in conflict with law. We have apprehended the child and we have produced the child in front of the JJ board. Now what will happen? How the inquiry will proceed? Inquiry should be completed within 4 months by the JJ board, and maximum another 2 months extension will be given to the JJ board. And if it is not done, if it is a petty offence, and if it remains inconclusive after 6 months, the act is very clear: terminate the case. That means it is in favor of the child. The JJ board cannot take the case for longer duration. And if you are extending the case, that means there should be a strong reason for the JJ board to continue the case. Further, if the preliminary assessment needs to be completed within 3 months, especially in heinous crime, that is, if a child between the age of 16 to 18 years has committed a heinous offence, then the preliminary assessment has to be done so that the case to be taken very fast and adjudicated. Further, the JJ board should ensure when the JJ board is dealing with the child, it should make sure the child is not harassed, ill-treated, and child-friendly procedure should be followed in the JJ board. And also, the child should be heard and should be given an opportunity to participate in the JJ board proceedings. These are the spirit of the JJ board. Further, if there is a petty offence, the JJ board can go through summary proceedings. That means it need not go into the details of the case, and witness summoning not required. A summary case proceeding is a very shortcut method, and since it's a petty offence, it can do a summary proceedings and finish the case very fast. If it is serious offences, that means summoning history will be done, and summoning case trial is the word it will be used. That kind of proceeding will be done. It will be slightly adversarial, but however, it is a JJ board, it should not enter into the adversarial procedure. But however, it should be dealt similar to summoning case that has been told. Moving to heinous cases, that means the JJ board will deal or a children court will deal in such a matter. So, the JJ board will deal petty offences and serious offences, and in heinous offences, whether depending upon the preliminary assessment, on that basis, either the JJ board will take or it will transfer the case to children court. Moving to the further, in case of heinous offence, alleged to be committed by a child who is between the age of 16 and 18. In such a case scenario, the board will ask for a preliminary assessment. And this preliminary assessment has to be done by either the board, or the board can take assistance from the psychologist or a social worker or any other experts like psychiatrist. If you want to know about the complete preliminary assessment, why it is done, how it is done, what is the method it is done, and what are the reasons it is done, please follow the link above to know about the preliminary assessment. Moving further. Under Section 15, preliminary assessment into heinous offences. That means if the JJ board to conduct a preliminary assessment, it will take help by the psychologist or a social worker or by a psychiatrist to know his mental and physical capacity of the child to commit an offence. That means whether the child has a mental and physical capacity. Further, ability to understand the consequences of the offence. And the third, the circumstances in which the alleged committed the offence. So these three important criteria has to be taken into consideration when the preliminary assessment is done. That is, mental and physical capacity of the child to commit an offence, ability to understand the consequences of the offence, and circumstances in which the child has committed the offence. So these need to be considered for the preliminary assessment. And if the board finds the child needs to be tried as an adult because the child has a capacity, physical capacity and mental capacity, child knows the consequences of the offence, and looking at the circumstances it has to be tried as an adult, then the board will transfer the case to the children's court. But one thing you need to understand, preliminary assessment is not a trial. It is to decide where the child has to be tried. I'm repeating that. Preliminary assessment is not a trial. It is to decide where the child has to be tried, whether it is in the JJ board or in the children court. Now, what is this heinous offence? I have been repeating many times. Under Section 2, subsection 3, it clearly says, the offences for which the minimum punishment under the Indian Penal Code or any other law for the time being in force, the imprisonment for 7 years or more is there. They are considered as heinous offence. Imagine the child is involved in conflict with law where the punishment dictated under the Indian Penal Code or any other law is 7 years or more. Those offences will be considered as heinous offences. Moving to Section 16, that is review of pendency of inquiry. If the 3 months once, the review will be done by Chief Judicial Magistrate or the Chief Metropolitan Magistrate. Imagine the JJ board is sitting and it is not doing its activity properly. That means the review has to be done. The review will be done by either the Chief Judicial Magistrate or the Chief Metropolitan Magistrate. Further, that is 3 months once. But however, 6 months once, a special committee consisting of the Executive Chairperson of State Legal Service Authority, he is High Court Judge. He will be sitting along with the Home Secretary and a representative from a voluntary or a non-governmental organization will be sitting with them and will review the cases of the JJ board. That means there is a 2 level of monitoring. One at the Chief Judicial Magistrate, another at the High Court by the Chairperson of State Legal Service Authority. They will be reviewing the cases of pendency. Further, Section 17 discusses about orders regarding a child not found to be in conflict with law. When the child is being adjudicated and they found child has not committed the crime, immediately JJ board will release the child. That means it will pass an appropriate order exonerating the child. Moving further, Section 18. Orders regarding a child found to be in conflict with law. Imagine the child has been found to be involved in conflict with law or else has been found to be guilty. And in such a scenario, the board will take certain important factors before giving their judgment. That is, the nature of the offence, whether it is a petty offence, serious offence or heinous offence. One, depending upon the specific needs of the child and the special basically social investigation report and past conduct of the child and also age of the child. So these important factors will be taken into consideration before the verdict is given. The board may consider following verdicts because if it is a petty crime, the board may say to go home after the advice. The JJ board may advise. Further, it may say, no, you need to undergo counseling. It can be individual counseling of the child or else a group counseling. It may be even a family counseling because the environment plays a huge role when the child is involved in a conflict with law, or else they may ask the child to pay a fine through the parents. Further, order the child to perform certain community services under the supervision of an organization or an institution or a specified person. That means the child may be asked to do some community services. That may be working for a orphanage home or else working in a old age home. In such a scenario, the JJ board has been given to rehabilitate the child rather than punishing the child, asking the child to do services for the community. Further, it to be released on probation by executing a bond. That means the child will be under close observation, or else the child may be placed in special home, or else asked to do certain education, certain skill development for the child, behavioral modification therapy, or else psychiatric support, or if the child has mental illness, then it will be referred to the psychiatrist. The board may also order the child to attend the school, attend a vocational training center, attend a therapeutic center, prohibit the child from visiting certain places. If the child has committed a crime and it wants to go to certain places, the JJ board can say you will not go to that places, or else the child will be also, if it is found to have addicted to certain substance or dependent on drugs or alcohol, de-addiction program can be referred by the JJ board. Further, the board may also order transfer of the trial of the case to the children's court. Imagine the JJ board comes to know the child had a physical and mental capacity, and also child knew the consequences of the act, and also the certain situation where the child has committed the crime, and considering all these bases, the case can be referred to the children's court to try as an adult. Till now we were discussing about the JJ board. Now we will discuss about the power of children's court. If the child is shifted from the JJ board to children's court, it will be shifted whenever the child between the age of 16 to 18 and has committed a heinous offence, and under the preliminary assessment clearly says the child has a sufficient maturity, that is with regard to physical capacity and mental capacity, and knows the consequences of his offence. At the same time, the social investigation report and the other report clearly says that child can be tried as an adult. It will be shifted to children's court. Now the children's court powers under this legislation is similar to the JJ board to conduct the inquiry against the child, and also need for the trial of the child as an adult. It will be dealt as an adult and the trial will occur. Further, the final order to be given by the children's court will have rehabilitation. In special circumstances, for example, if the child has been punished, but however, the child has crossed 18 years, now where should we send this child? Should we send the child to the special homes or else to the prison? Here the legislation is very clear. It clearly says, in such a scenario where the child is between 18 to 21 years, in such a scenario, child has to be sent to a place of safety till he attains the age of 21 years. Thereafter, the person will be shifted to prison or the jail as similar to adult. Till the age of 21, periodic follow-up report every year by the probation officer or the district child protection officer or a social worker has to be submitted to the children's court. What happens after 21 years? After 21 years, the children's court can, looking at the child's behavior or the reformation or rehabilitation, it can decide to release or else transfer the child to the adult prison. So many of them have criticized about this, but however, the legislation is very clear about this. Suppose Section 21, order that may not be passed against a child under the children's court. We discussed about the powers. At the same time, the legislation also says the children's court does not have a power to give death sentence or life imprisonment against a child. So that is beautifully has been clearly told. It has been given a power, but at the same time, it also has been said the children's court does not have the power to give death sentence or life imprisonment. Further, in Section 22, proceedings under Chapter VIII of the CrPC of 1973 not to apply against child. Here, the legislation is very clear. Notwithstanding anything to the contrary contained in the CrPC 1973, that is, Criminal Procedure Code 1973 or any preventive detention law for the time being in force, no proceeding shall be instituted or no order shall be passed against a child under Chapter VIII of the said code. That means the child has committed an offence. Now, you will not do preventive detention of that person repeatedly. That is what the crux of the matter under Section 22. Moving to Section 23. No joint proceedings of a child in conflict with law and person not a child. I'll give an example here. As you know, the Nirbhaya case, there were many accused. Only one was a juvenile who was 17 years. Remaining were adult. Now, whether all of them will be tried in the Juvenile Justice Board or Children Court or as a criminal court. The law is very clear here. No joint proceeding. Here the child will be tried in the JJ Board or Children's Court. Whoever is the adult who is with the child will be tried as an adult in the criminal court. That's what it says. If you look at that, it clearly says there shall be no joint proceeding of a child alleged to be in conflict with law with a person who is not a child. If a person is not below the age of 18, he will be tried as an adult in the criminal court. Moving to Section 24. Removal of disqualification on the finding of an offence. This is another very important section. Even if the child is found in conflict with law, this act shall not disqualify for applying for any job or any future prospects. That means here the child is in conflict with law and you will not use that against the child. Imagine somebody has committed a crime at the age of 17 and he has been punished. But if he wants to apply for government job, since he is convicted, will he be allowed to apply for a job or not? The act is very clear. He will be allowed to act. He will be allowed to apply for the job. He wants to stand for an election. He will be allowed to stand for election because nothing in the law will prevent him doing that. Because when he did a crime when he was a child, he did not have sufficient maturity about this. And also, it also clearly says the board shall make an order directing the police to destroy all document after the expiry of the period of appeal. Imagine, the JJ board has conducted the inquiry and given the punishment. If they appeal, fine. If they don't appeal, that means the JJ board will tell the police to destroy all the documents. And if it is a heinous offence, the children court will retain the records, not the JJ board. Neither the police will keep the records in their police station. That means anything against the child will not be kept as a record. It has to be destroyed so that the fresh start has to be given to the child once he crosses 18 years. That means he will be considered as he has not done an offence so that the rehabilitation occurs. Further, Section 25. Special provision in respect to pending cases. Imagine when the law was implemented, maybe in 2015, again in 2021, all proceeding in respect to a child alleged or found to be in conflict with law pending before any board or court on the date of commencement of the act shall be continued in the board or in the court as if this law was not enacted. That means whatever the case till now is there will continue similarly. This law will not apply to them. Whoever has committed the crime after the passing this law will be considered under this law. That's what is the crux of the Section 25. Moving to Section 26. Provision with respect to a runaway child in conflict with law. Imagine a child is involved in a conflict with law and he's been apprehended. And he escapes from the custody of the police or SGPU or else from the child welfare police. In such a scenario, the police is being given power to take charge of the child and he will be produced in front of the JJ board immediately. Since he has escaped, there will be not an additional charge or additional proceedings will not be against the child. Imagine if an adult escapes from the prison, there will be another case against him to escaping from the lawful custody will be given. And that means it will be again one more proceeding will be there against the person. But here, there will be no extra proceedings and the SGPU, that is Special Juvenile Police or the Child Welfare Police, can take the charge of the child. Here, it is not called as an arrest. They will take charge of the child and they will produce the child in front of the JJ board. To conclude, my dear friends, the child in conflict with law should be treated with the dignity. And you need to understand, a child commits a crime because the brain is still developing And because of the complex situation in our society, because of poverty, because the child may not have the parents, or the parents who are there are not responsible, and the child may itself has various other problems, maybe social problems, economic problems, may get involved in the crime. In such a scenario, you need to take the child's social circumstances into consideration before the child is tried as an adult, or else tried in the court. It has to be tried in the Juvenile Justice Board. And section 4 to 26 are clearly dealt under the Juvenile Justice Act, that is chapter 3 and 4. And whenever the proceedings are done, the rights of the child has to be upheld during the process of the adjudication, during the rehabilitation, and post release. And in post release, no records against the child will be kept, even if the child has been convicted under the JJ Act. Thank you very much for giving your valuable time. Stay safe.